It says that, look, we are creating a right to food, but the entitlement that we are creating under this right to food will only be for 67% of the Indian population. I think this is a disregard of the spirit of constitutionalism. And I think that we have somehow fallen prey. We have struggled a lot. And let me tell you, it's an incredible struggle over the last 13 years. We have struggled a lot to get something out of the state so that we are able to deal with the problems of hunger and starvation. But I think somewhere in our struggle, we have not kept sight of what is the principles of constitutionalism that we should have followed in order to ensure universality. And we have made compromises because the present circumstances and the nature of the state in India in present times do not allow us to have what we want. We are settling for less. I don't know if it is really a step in the right direction. I feel sometimes it is, because one sees practical benefits. Now, I cannot argue with the fact that the National Food Security Bill will increase the coverage from 36% to close to 70%. It will bring down the prices by half. Today the BPL is at, the rice, wheat are accessed at anywhere between 5.5 to 6.5 rupees. They will be accessed at 3 rupees and 2 rupees. And you can get millets at 1 rupee. I cannot argue with that. I cannot argue that it will bring relief to a large section of the Indian population. But I'm still uncomfortable. Because to me, the job of lawmakers was, when they were framing this law, was to go back to the constitution, was to go back to the jurisprudence that has been created over the last 30 years on the right to food in India, and ask themselves that when we have this jurisprudence, when we have these constitutional principles, should we have a right to food that is not universal? And that is my discomfort with some of these laws. People's Union for Civil Liberties, which is one of the very eminent human rights organizations in the country, filed a petition in the Supreme Court. They went to the Supreme Court in 2001 when we had this extraordinary situation of 66 million tons of food grains in the godowns, and a large number of people being poor and dying from hunger and starvation because the state of Rajasthan had seen its third recurrent year of drought. So they gathered a lot of data and they went to the courts and said, Your Lordships, we have a very simple demand that for the state of Rajasthan, we have a very clear violation of Article 21 because Article 21 encompasses the right to food. And therefore what we want you to do is to look at the amount of food grains we have in the godowns, look at the number of food schemes the government has, and look at the situation on the ground. All we want is that the government address this, and they gave a series of concrete measures, the most significant of which was that the state of Rajasthan should increase the programs for food for work. There were employment programs in those days, Sampurna Gramin Rozgar Yojana, SGRY1 and SGRY2 during the earlier decades. All the petitioners were asking was an interpretation of Article 21 which would lead to the increase in programs where people could work, and in lieu of the work that they did, they would get food grains. But look at what the Supreme Court of India did. When they saw the data, when they saw the extent, the scope of the problem, they said that no, this is not a problem that affects only Rajasthan. We are interested in this because we see a systemic violation of Article 21 across the country. Rajasthan is not unique. So they extended this case. Please remember, this case was not a national case. It was not a case which affected the entire country. It was the courts which interpreted it. And the courts which said and asserted and reaffirmed that this is a case that affects everybody. And they extended it to the entire country. They served notices to all state governments. And they said, look, we must know what is it that you are doing to address the situation. And because it got extended to the entire country, PUCL was a small organization. They had a small presence in Rajasthan. They couldn't do the entire country on their own. The Right to Food campaign was born. And this was a campaign which in the initial years was very closely linked to the court case. And the primary purpose of the campaign in the initial years was to ensure that we were able to collect data from across the country to make affidavits for the court and to counter the misinformation that state governments were putting in the court. And that's how the campaign started. But very soon it took a life of its own, and today The Right to Food campaign is a very, very vibrant group of 2,500 NGOs, trade unions, political activists, academic institutions across the country. 2,500 groups are linked to the Right to Food campaign. It has a presence in large part of the country. And the key issues that this campaign did was to make the right to food a fundamental right, to convert all existing schemes into entitlements, and to tackle large-scale malnutrition and chronic hunger. And lastly, to secure employment as a fundamental right linked to the right to food. That struggle on employment was somewhat resolved when the left political parties, who were a very significant player at that stage, along with groups like the Right to Food campaign, joined forces, and the left liberal community in India joined forces to ensure the passage of the National Rural Employment Guarantee Act. We've actually had, this is a mistake, we have more than 151 interim orders in this case. And what are the highlights of the Supreme Court orders on the right to food? It has converted all the food and employment schemes into legal entitlements. It has universalized food entitlement programs for children under the age of 6 and midday meals. Remember, this is the Supreme Court doing it. We did not have a universal midday meal scheme. We had a very limited midday meal scheme. And I was present in court when those arguments were being made. And the Solicitor General stood up and told the court that while the government agreed with the court in the intent of the midday meal scheme being universalized and covering 160 million children in the country, the government did not have the resources to do so. And from time to time, what Justice Kuldeep said to the Solicitor General, it echoes in my ears from time to time. He turned around and he said, Mr. Solicitor General, are you telling that after 60 years of independence, we don't have enough money to feed our children? And he said, I quote, please tighten your belt elsewhere. Please tighten your belt elsewhere. And he passed this landmark order in November 2001, which universalized the midday meal scheme. What that meant is that government had to raise the revenue, and so they imposed a 2% cess on petrol in order to raise the revenue for education. And even now, every time you buy petrol or diesel, every time you buy fuel, there is a 2% cess that is used, and part of that money goes to cover the midday meal scheme. Around 2 years into the case, around 2003, the courts also realized that governments were not representing data correctly. Those of you who've traveled around Delhi, you will see that a large number of people are homeless. They are on the streets. Government of Delhi filed an affidavit in the Supreme Court, and they were not alone in doing that. The government of Punjab did it, the government of Himachal did it, a number of governments did it. There was a scheme to cover the poorest of the poor, and there was very poor implementation of this scheme in Delhi and with these governments. And they filed an affidavit, these governments filed an affidavit in court saying, look, we couldn't implement this scheme because in our state, there is no one who is poorest of the poor. Now that is a claim that even the most developed society in the world cannot make. And if you step out, you will see people sleeping on the streets, you will see people in conditions of absolute destitution. And yet the government did it. And that's when the court realized that they need their own institutional mechanism to monitor the food schemes of the government. And they needed somebody who can direct state governments to act on behalf of the court. They needed someone who could inform the court about compliance with Supreme Court orders. And they instituted the office of the Commissioners of the Supreme Court as an independent mechanism. They prevented the government from reducing the poverty line. The Supreme Court prevented the government, forced the government's hand and prevented it from reducing the poverty line to 26%. Imagine if in 2003 the government had succeeded using a thin round of data from NSSO to reduce the poverty line to 26%, what would have been the state in the country? And the court has not hesitated to serve contempt notices to chief secretaries, some of the senior most officials, bureaucrats, summoning them to court. There are 13 instances where they have been summoned and hauled up for not implementing the orders of the court. So it is, as a continuing mandama, should be something where the court is regularly monitoring through the Commissioner's office on a day-to-day basis almost the food and employment. And the mandate extends of the Commissioner's office to entitlement feeding programs, to employment programs, to the food subsidy programs, to social security programs. The position of the Commissioners is honorary, its work supported by funds mandated by the Supreme Court, and so on. And the Commissioners play a very wide role, including participatory researches, making alternative demands on state policy, and also now over the years we've become part of many policy bodies, advise many policy bodies such as the Planning Commission, steering groups, and so on. This is some of the impact that I spoke about, but I'm going to cut it short here because otherwise we won't have too much time for discussion. So friends, I want to first answer your questions that you may have, and then we can actually go into a group discussion to see if there's some common threads that are emerging from your countries and what is the potential for litigation, what is the potential for legislation, and so on. And I could talk about the National Food Security Bill a bit also if there's time. But let me begin by just throwing the floor open for questions, comments, queries, clarifications, if any, and then we'll take it from there.